All right. Because we've hit over 100 attendees in this webinar, we are starting a YouTube live stream. So if you can be patient with us while we start this up, and then we'll begin the event. All right. Okay. Dean Krug, let me know when you're ready to go, and I will stop the screen sharing and we'll start the event.
Well, I am ready to go right now, so I'll get things started. And I'm really happy to do that. So, hi, everyone. I am Dean Anita Krug, and it is wonderful to welcome each of you to our annual Palmer Lecture to honor this year's recipients, or actually the 2019 recipients of the Chicago-Kent Roy C. Palmer Civil Liberties Prize. This event was originally scheduled for April as an in-person event, but of course, events overtook us. So the Palmer Prize was established in 2007 by Chicago-Kent alumnus Roy C. Palmer and his wife, Susan M. Palmer, to honor exemplary works of scholarship exploring the tension between civil liberties and national security in contemporary American society. Roy Palmer was a lawyer and a real estate developer, 1962 honors graduate of Chicago-Kent, and a member of Chicago-Kent's Board of Advisors. In 2012, he received the Chicago-Kent Alumni Association's Distinguished Service Award, and in 2013, he was named as one of our 125 alumni of distinction. Before his death in 2017, he and Mrs. Palmer were active in numerous civic, social, and philanthropic organizations. Today, joining our list of distinguished scholars who have won the Palmer Prize in past years are Abraham Newman of Georgetown University and Henry Farrell of Johns Hopkins University. They are being honored today for their 2019 book, Of Privacy and Power, The Transatlantic Struggle Over Freedom and Security, published by Princeton University Press. Professor Henry Farrell is the Stavros Niarchos Foundation Agora Institute Professor of International Affairs at the School of Advanced International Studies at Johns Hopkins, 2019 winner of the Friedrich Schiedel Prize for Politics and Technology, and editor-in-chief of the Monkey Cage blog at the Washington Post. Previously, he was a professor of political science and international affairs at George Washington University. His research focuses on a range of topics, including democracy, the politics of the internet, and international and comparative political economy. He is the author, in addition to the book that he and Professor Newman will discuss today, he's the author of The Political Economy of Trust, Interests, Institutions, and Interfirm Cooperation, published by Cambridge University Press in 2009, and tens of academic articles in a range of academic journals. Professor Abraham Newman is a professor in the Edmund A. Walsh School of Foreign Service and the Government Department at Georgetown University, and also the director of the Mortara Center for International Studies. His research focuses on the ways in which economic interdependence and globalization have transformed international politics. He is the co-author of, or editor, or author of a few books, including Voluntary Disruptions, International Soft Law, Finance and Power. Publisher was Oxford University Press in 2018. He's the author of Protectors of Privacy, Regulating Personal Data in the Global Economy. That's Cornell University Press in 2008. And co-editor of How Revolutionary Was the Digital Revolution, National Responses, Market Transitions and Global Technologies, published by Stanford University Press in 2006. His articles likewise are numerous, and have been published in a range of prestigious journals. So with that, I will turn things over to Professors Newman and Farrell and thank them so much again for being with us today.
Wonderful. Well, let me begin. We are going to deliver the lecture jointly. I shall begin, and Abe will put up slides, which will provide a background, and then Abe will complete the lecture. So before we begin talking proper, we wanted to express our gratitude both to the School of Law and to Roy and Susan Palmer for the extraordinary honor that we feel has been bestowed upon us. We are extremely grateful to be given this award. It's a wonderful award. It's extraordinary to have this award for books which look to speak to civil liberties in the United States and elsewhere. And we feel deeply, deeply, deeply honored, as I say, that we have been chosen among what must have been a field of pretty wonderful books to receive it. It's our great regret that we're not able to give this lecture in person as we had originally hoped to do. But as we all know, we are in a situation where we are making the best we can out of unfortunate circumstances beyond our control. So Abe, do you want to put the
Yep, I was just going to ditto everything Henry said. We're really touched, and it's an amazing honor. I mean, any author, you imagine you send your book out into the world and nobody reads it, but somebody read it and they liked it. So we're very honored, and we just want to say thank you again. And with that, I turn it over to Henry to start the talk.
And also thank you to Anita so much for the wonderful introduction. So we're talking today about our book of Privacy and Power, which was published in 2019, hence its eligibility for the award, but which covers a set of topics and a set of questions which are still ongoing. So let's see, I seem to have lost the, perfect. So this is our book. Those of you who haven't had a chance to read it yet, we recommend very much, obviously, that you do, because we think it is a wonderful book. But it is a book which speaks to a set of questions, a set of concerns which straddle the United States and Europe. So one question, if you think about this from the perspective of the Palmer Prize, which looks to talk about civil liberties in the United States, is that civil liberties in the United States and in Europe have become deeply enmeshed with each other. And we see this in this picture here. This is a picture of the CEO of Apple, Tim Cook, giving a speech in the European Parliament in which he is advocating European privacy rights and saying that the United States should effectively follow on the lead of the European Union. And that's the kind of speech which is unusual for an American CEO to give, and which one mightn't have imagined an American CEO giving 20 or 30 years ago, but which reflects the ways in which the privacy politics and the civil liberties politics of the European Union and the United States, these two great powers which are also dedicated to democracy, the ways in which these two jurisdictions have become intermingled with each other. So why is it that this has happened? How did this happen? What are the causes behind it? That is the topic that Abe and I have chosen to look at in our research, and that is the source of the book that we are talking about. Next slide. And so what we want to get away from is a standard way of thinking about the world and thinking about this relationship between these two great powers, which are also committed to civil liberties. Very often there is a standard story which we associate with people like the foreign policy thinker Robert Kagan, which is that America is from Mars and Europe is from Venus. In other words, America is a martial power. It is a power which is committed to force. It is a power that is committed to toughness. And Europe instead is committed to the softer, kind of more civil liberties, touchy-feely way of thinking about the world, and in which you might expect to see these two powers, when they come up with stuff, they come into conflict with each other. And this is a story which you see in a lot of journalism. A lot of public punditry, a lot of commentary suggests that when you look at issues such as privacy, this is a conflict. It is a conflict between between a United States system, which is very much resistant to privacy, very much resistant to civil liberties, and a European system, which is much more privacy friendly and which has embodied many of these privacy and civil liberty commitments in a set of major documents and major laws, which lead inevitably to conflict across the Atlantic. So this is a story of clash between systems, of clash between the United States as a whole and the European Union. Next slide. What we think instead is that the world is a very different world from that. It is not a world in which you get these kinds of big, simple clashes between different major jurisdictional systems happening in the uncomplicated way that standard stories tell you that they do. Instead, we argue that openness has consequences. And what we mean to say by this is that if you look at the European Union and the United States, if you look at their economies, if you look at their jurisdictions, their rules, all of these are deeply bound up with each other. Now, for example, if you look at a different area, if you want to have a merger of major businesses, you have to have permission both from European and United States regulators. And this applies across a wide variety of different topics, including civil liberties topics. So if you want to understand the fight over civil liberties, the fight between people who are more committed to a more pro-security perspective and people who are committed to a more civil liberties perspective, and again, that is a somewhat crude way of putting it, you want to look not at the struggle between the United States and the European Union, but you want to look at the way in which these arguments are conducted across these jurisdictions. That is the key point that we want to make, is that if you want to understand what is happening, it is not a fight between Europe and the United States. Instead, it is a fight across these jurisdictions where you see these cross-national alliances happening between some actors in Europe and some actors in the United States who are more committed to civil liberties, and in this case, privacy and data protection, and other actors, again spanning the United States and Europe, who are much more committed to the pro-security way of thinking about things and who don't want to see civil liberties that they feel unnecessarily threaten the security of citizens. They don't want to see these liberties getting in the way of what they see as being the real job of democracies, which is to protect the citizens. And this is why you see people like Tim Cook talking in the European Union, talking in the European Parliament, and using this as a means to try and leverage change in the United States. This reflects the ways in which the United States and the European Union's jurisdictions and ways of doing things have become fundamentally entangled, and how this creates this possibility for alliances across. Next slide. So this is what we call the new interdependence approach. We're political scientists, and political scientists have a lot of jargon. So interdependence is one of those jargony words, which refers to the ways in which states increasingly they become interpenetrated with each other, so that what happens in one jurisdiction increasingly has consequences for another. Rather than looking at politics as being a battle between states, we want to look at the ways in which this interdependence transforms states, transforms jurisdictions, and leads to all of these different kinds of intermeshing and overlap that then have political consequences, and in particular have political consequences for privacy and other liberties. Next slide. So here we make an argument that emphasizes two important ways in which this happens. First of all is what we call rule overlap. And the idea here is very straightforward, and it should be familiar to those of you who are lawyers. This is the kinds of problems that are discussed when we talk about conflicts of laws type questions, is that you have different jurisdictions with different rules, and very often these rules clash with each other. Very often these rules impose different kinds of obligations upon the actors who are subject to them, and increasingly these clashes have consequences as these jurisdictions become enmeshed. You begin to have questions over which rules ought to predominate under which set of circumstances. You get political fights and struggles happening as a result, with different coalitions of actors preferring that one set of rules predominate and that the other gives way, or vice versa. And you also have efforts to try and craft compromises between different jurisdictions, different sets of rules, in order to try and minimize the friction. Next slide. And so this also goes together with opportunity structures. So when you find yourself suddenly thrust into this new arena in which there's overlap between different jurisdictions, this can provide all sorts of complicated and unexpected opportunities for actors to try to engage and to try and push their agenda forward, perhaps to the detriment of other actors. So that, for example, if you are a US privacy activist who has been looking to push back against what you see as being the depredations of big platform companies, which are politically powerful in your home jurisdiction, when you see the European Union beginning to take an interest, this may provide you with new opportunities to get things done. Similarly, if you're a European who is unhappy with the way that the United States is doing things, you may find, even if you are an ordinary citizen or an activist who is excluded from the corridors of power, you may find new opportunities being given to you to try and reshape how this works. Next slide. So this then leads to a much more complicated international arena than we're used to. It leads to one where you still have the traditional kinds of things that happen when states interact with other states. You have diplomats negotiating, you have officials talking to each other in various official meetings. But in addition to this, you get a whole bunch of other actors suddenly thrust into the arena, suddenly trying to figure out what kinds of opportunities might be open to them. And I think this is where I turn over to Abe.
Great. So the last point that we want to make in the kind of the theoretical argument is that what you have these new transnational settings, it's not just about what's happening within the United States or within Europe, but the different factions, these groups within society, they're using these transnational spaces to change policy. But as Henry mentioned, these policies are asymmetrically distributed. Not everybody has access to these new globalized structures that they can use to transform politics. And this is just an example from a G20 summit that was held in Hamburg, where you see that there's a whole security zone where people that are doing demonstrations, they're not allowed in. And so, global NGOs have fewer opportunities at this moment than, let's say, public officials. And we're going to really explore how different groups exploit this asymmetric access to their advantage in the case of privacy and civil liberties. So one of the things that's very interesting in the privacy domain is what we're seeing most recently is how those groups that have been excluded from these transnational domains are increasingly targeting their domestic political arenas in order to fight back. And I'll talk more about this later when we get to the case of the Schrems decisions, but it's a critical example of where just because you can't shape the global arena, you do have chances at the domestic arena to block those global forces. So let me get now to kind of the heart of the book of what happens in our analysis of transatlantic privacy relations. We start with two different factions. The first is the faction that is really thinking that they want to promote surveillance. And this group is both in the United States and in Europe. And they're facing, going into the 1990s, very different domestic rules about privacy and civil liberties. So in the European Union, they already have a very robust set of privacy regulations that were started at the European, or that were created at the European level. And in the United States, you have only scattershot privacy laws, focusing primarily on the government and not on private sector actors. And so after 9/11 happens, after the terrorist attacks, groups within both societies are looking for more access to this data, US actors and European actors. And what we tell in the story of the book is how there is actually a cooperative effort. Here you see Michael Chertoff, who was one of the first secretaries of Homeland Security, and Wolfgang Schäuble, who at the time that we're recounting was the interior minister in Germany. And here we tell a story of not Germany versus the United States or Europe clashing with the United States, but actually two savvy actors working behind the scenes at the transnational level in order to create a set of agreements at the global level that will skirt the rules that were in place at the domestic level. And we're just going to briefly mention a few of these. So in the period of a few years, the United States and the European Union, after this kind of collaborative alliance politics between these actors, these security actors, they sign a set of agreements. You get the SWIFT agreement, which allows for the transfer of financial data from the United States to from the European Union to the United States. You get the PNR, the Passenger Name Records Agreement, which creates the ability for European airlines to transfer data to the United States. You also get something that's called the Umbrella Agreement, which allows for other government data to be transferred across the Atlantic. And in each one of these cases, these transfers are really going up against domestic rules within Europe. Europe has comprehensive data privacy laws, and just on face, these laws seem to block these types of transfers to the United States. But what the Security Alliance does is they layer a set of agreements on top of those domestic rules, which then allow almost like a separate pipeline for data transmissions between the US and Europe on these security issues. And what we also demonstrate in the book is that over time, these agreements don't just allow information to move from Europe to the United States, but it also undermines European, or it allows the security coalition in Europe to get domestic change within Europe. So if you just take the case of the passenger name record, what starts as an agreement between the US and Europe then gets used by European officials to transform domestic European law. For many years, the security community within Europe had been hoping to get access to this passenger name record data, and they kept being blocked by European privacy law. After the signing of the EU-US PNR agreement, then European officials, they use this as a political cudgel to argue that we have to do this. We're already being asked to do this by our European allies. They're getting so much benefit from it. And they use that story as a political weapon in order to open up and liberalize data exchanges within Europe. But as we mentioned at the beginning of the story, this is really only one part of what's going on. This part of the story is how the security community is using globalization to layer on, let's say, data, more liberalizing data transmission rules and to eat away at the domestic privacy laws within Europe. But at the same time, you have another faction, a competing faction, which is a civil liberties community. And they are really working both transnationally and domestically in order to push back against what's happening by the security coalition. And here on the one side, you see actors in the United States like Edward Snowden, who has the glasses. And then on the right, you see, Max Schrems, who is a lawyer in Austria who is promoting civil liberties responses within the European Union. And what we show in the book is that this community does not have access to the transnational institutions that the security community has. They cannot come up with a set of transnational rules that can solve the uncertainty created by rule overlap. But instead, what we show is that these actors use the information that they receive by transnational networks in order to target and shoot down those transnational encroachments on civil liberties. And so if you think about, there used to be two jurisdictions, the United States and the European Union. They had their own domestic rules. All of a sudden, there were these transnational rules that are starting to erode domestic protections. What these actors are doing is not necessarily building back up the domestic rules. I mean, they try to do that too, but instead they're insulating their home jurisdictions from those transnational attacks on civil liberties. And I'm just going to quickly walk you through how they do this. So after the Snowden revelations, it becomes clear that the United States is getting data from private sector companies that it is using to target terrorists and other actors. And so data coming from the European Union is not just staying in the hands of those private actors, let's say Amazon or Facebook, but it is being directed further on to the NSA. And the Snowden documents detail in quite excruciating pain how this works. Programs with very kind of crazy acronyms like PRISM or Storm Brew, they're all examples of programs where the NSA, in effect, was leeching onto data transmissions to private companies and then using them for their own purposes. And what Max Schrems does is he says, look, that technique of Europe giving information to US private actors and then private actors giving that information further to US national security agencies, whether they intentionally do it or not, is in breach of the agreements that have been signed between the United States and the European Union. In particular, there was an agreement called the Safe Harbor Agreement, which allowed US companies to get data from Europe and house it in the United States as long as they would comply generally with the standards created in the European Union. And the Snowden documents demonstrate that that's not happening, because a core principle of the Safe Harbor Agreement and European privacy rules is that data cannot be transferred further from the intended recipient. And so the Snowden documents demonstrate that is happening. And Schrems has a new way to challenge these data transmissions, because before the Snowden revelations, he basically was stuck with that Safe Harbor Agreement, which had legitimized and allowed data transmissions from Europe to the United States. But once the Snowden revelations make clear that there is this further onward transfer, it gives him a political and legal wedge into this data transmission ecosystem. So he brings a case originally in Ireland, because that's where Facebook is headquartered, and then the Irish High Court rules, basically in his favor, but pushes it up to the European Court of Justice, which then ultimately, in the first Schrems decision, nullifies the Safe Harbor Agreement and rules in his favor that because of this further transfer to national security agencies, that the United States cannot guarantee the security of that information. As I mentioned before, what this really does is it strikes down the Safe Harbor Agreement. If you see in the blue, that's where there's European data being processed. It's going through the Safe Harbor Agreement, this pipeline, into a company like Facebook in the United States. What Snowden reveals and what Schrems activated was the reality that was being transferred on to the National Security Agency. Now the question is, what is going to happen? There was an interim agreement, which I'll talk about in a second, which is the Privacy Shield. But right now what we're seeing is that there's a new uncertainty about what are the political interests of Silicon Valley. As Henry began to talk about, you see Tim Cook going to the European Parliament and saying, I'm for European privacy rules, the current laws that Europe has passed, the GDPR, the General Data Protection Regulation. He's saying we should adopt those in the United States. Well, why is that happening? And we would argue that it's this type of transnational alliances that are being formed. This isn't because Tim Cook loves privacy and he thinks that this is the thing that's going to sell more iPhones. What he thinks is that this is a great way to put pressure on many of his competitors like Facebook, because ultimately, Apple is not primarily a data processing firm. They're a hardware firm. But when they look across at their other competitors in Silicon Valley, they think about Google and Facebook as really data-driven. And so here's an opportunity for Apple to create a transnational alliance where he's putting a bet on the future of surveillance capitalism, in which he's saying, Apple might benefit from stronger data privacy rules in the United States, and he can use the European position to flip the United States. And we would argue that this is really, it's just another iteration in the story that we told earlier about both the security community pushing their security agreements, and then the civil liberties community pushing back. Now, here's a picture of Kristen Nielsen, who was I think the last confirmed secretary of the Department of Homeland Security. There is a currently ambiguously appointed person. We're not sure if he's really legally there. But anyway, one of the things that's very interesting is that right before she was fired by President Trump, she was on a European excursion to discuss with European officials how they might engage in counterterrorism efforts. And the thing that I think was very striking for us was that this was one of the reasons Trump supposedly fired her is he argued that he was frustrated because she was just gallivanting across Europe. And what is the Department of Homeland Security even doing that for? And in our mind, this is really the U.S. government not really understanding anymore how global politics is being played, because what she was really doing was exactly what our argument would say she should be doing, which was that she was shoring up a community of people that all share her interests, which are in tighter data sharing and security interests. And Trump's firing of her is a signal about the disconnect between potentially how the world is working right now and how the Trump administration was playing. On the flip side, you see privacy advocates, they're taking on a whole host of new opportunities to engage this transnational level. Here you see this is a story about a German privacy agency that they are going after Microsoft's privacy protections and arguing that schools in Germany should not be using Microsoft Office because of the cloud system that the Microsoft Office is using and relies on. And I think what we want to argue is that these legal systems, they don't just give an opening for privacy activists to go after domestic political concerns, but they also let them target these transnational companies and the things that they are doing. And then Microsoft's response is to change the whole Office 360 system, 65 system, in order to meet these privacy demands. So what's coming next in the US-European privacy relationship? And this is a huge uncertainty. After Max Schrems wins the Schrems 1 decision, the European Union and the United States, they come up with something called the Privacy Shield, which I think is just a slightly warmed over version of the Safe Harbor Agreement. It continues to allow companies to transfer data between the US and Europe based on European privacy rules, but it never really solves the key issue, which is that can Europeans trust US companies not to give their data back to US national security actors? Or can we trust US national security actors not to hack into or figure out some ways to acquire private actor data? And so this year, Max Schrems won the Schrems 2 decision, which strikes down this Privacy Shield agreement, and where the European Court of Justice rules again that it does not provide sufficient protections in order to justify the transfer of data. And so we're now really kind of stuck in a very ambiguous place where there's no legal certainty around data transfers between the US and Europe, except for private company standard contractual clauses. Companies basically saying we will comply with these privacy agreements. And most recently, European officials have kind of been split, even if those could stand the muster of the European Court of Justice legal system. And so I think what we're going to see in the coming months is a debate between the Biden administration and the European Union about what can we do in this space. And I think, it really creates an opportunity, at least Henry and I think so, for a new way to think about how privacy and civil liberties go together. I would say for several years, the security community within the United States was really pushing back and saying the US way it should be the European and the US way. It should be one where there's open data transfers and really loose sets of protections around use when it comes to risky situations. And what we argue in this piece is that given the rise of China and the new threats that, let's say, 5G mobile technology presents, there's a new opportunity for civil liberties activists to argue for a rethink, to say, security and civil liberties really aren't always in tension with each other. They can also shore up the legitimacy of surveillance operations. So if you think right now how this plays out in a world where there's the US, Europe, and China, Europe sits in the middle, where they're worried that they could be spied on by the Chinese or they could be spied on by the United States. And China has basically said to Europe, look, we have a better information technology infrastructure. We'll roll it out. And yes, you have to worry about spying, but you have to worry about that anyway with the United States. And the United States is not on the best footing when they just say, well, good luck, Europe. You have to just trust us. But instead, there's an opportunity to extend civil liberties to the transnational level, to have a US and European agreement on a set of privacy practices that would protect the citizens of both jurisdictions, to underpin that with the rule of law and democratic principles that really are the foundation of the transatlantic relationship. And so just as the security community across the Atlantic pushed an agenda to loosen restrictions during the 2000s, you could imagine a civil liberties community that's not just trying to insulate themselves from those efforts, but that could be creating a transatlantic space that has a set of privacy protective principles that facilitate surveillance when necessary, but embed it within a clear set of safeguards for both European and US citizens. And that would be something that I think would be a strong pushback against a Chinese 5G system, is to say, well, actually, this Western alternative has a grounding in democratic principles and privacy and civil liberties protections. Ultimately, this calls for a much broader rethink of how do we, as the US and Europe and in the globe, think about globalization when it's being turned increasingly for coercive ends. As global information networks, whether it's TikTok or Google, are being used by states in order to surveil societies, how can we manage that, maintain globalization's benefits, but limit these vulnerabilities? And in a set of work that Henry and I call weaponized interdependence, we've been thinking about how to manage this type of chain globalization. What are the rules of the road that should be out there so that it's not just seen as an easy opportunity to avail yourself of, but that actually we need to, limit the overuse of these types of tools, or otherwise we risk crashing the whole system. So finally, just to conclude, we want to set out a different way to think about the politics of civil liberties and privacy. We want to argue it's not about clashing systems, the US versus the United States, but really it's a politics across jurisdictions where coalitions in both communities, civil liberties coalitions, security coalitions, are reaching across the Atlantic to try to achieve their political interests. The second thing that we want to kind of underscore in this book is that that information has really become a core problem for global politics and law, that you cannot think of national security today without thinking about TikTok. No, who would have thought about that, even 10 years ago, that these databases, which contain so much personal information, they are a map to our lives. And when governments have access to them, that is an extremely powerful resource that can be both a good thing to manage problems and crises, but also a tool of control. The third point is that we just want to think about the future of the transatlantic space for freedom and security. And here, as I mentioned just a little bit ago, we think that the Biden administration could crack this nut in a new way. Not just say, okay, Europe, we're going to do the minimum possible to pass your, get some kind of, we'll call it like a minimal deal, but instead to rethink the interaction between security and civil liberties in a way that would really both legitimize our surveillance operations and legitimize our position vis-a-vis China. The final point, which kind of dovetails to this, is thinking about the new Secretary of State and the new Director of National Security Council. These are people who have given a lot of thought to the role that maybe an alliance of democracies might play in a future world community. And there, we think that the politics of security and civil liberties fits right in. And it's really an issue that could be something championed by the US and Europe as an example of where democracies can stand up and embed their security communities within the rule of law and proper use of information. And with that, I'll stop.
Thank you. The question we have in the Q&A at the moment, if anyone else would like to add to them, that's fine, is from Martin Stainthorpe, and he says, how does the U.S. campaign against the Chinese company Huawei, I'm probably butchering that, alleging data security concerns and the U.S. effort to recruit the EU against Huawei fit into this model?
Let me respond to that first, and apologies. I'm dealing with one of the occasional problems of Zoom calls, which is competing leaf blowers engaged in a fight for dominance and ascendancy in the background. So the answer to that question is that it poses some interesting problems and challenges. European officials have made it clear that they are quite distrustful of the model of information management that China is offering. They are very skeptical about what could happen to European data if it is transferred to China, but they are also very, very worried, as Abe described, about the ways in which the United States continues to advocate international surveillance with very, very little in the way of legal bounds. So if you look at the privacy shield, which Abe described, effectively this was a description of existing US intelligence community practice with a couple, with a little bit more of oversight, with some rather vague redress possibilities, which were attached to officials within the US government, which the European Union did not think necessarily were going to provide an unbiased, sort of a neutral adjudicator in cases of dispute and disagreement. So there very clearly is the possibility, as Abe said, for some kind of common work between the United States and the European Union to try and build a more privacy and civil rights friendly international jurisdictional approach across democracies. But one of the plausible and necessary conditions for this is that the United States stop regarding surveillance of other democracies as being something which is outside of the scope and the reach of law, and instead start to think about ways in which, when it is spying on a mass level on the citizens of other democracies in their ordinary lives, these citizens need to have actionable rights and actionable ways to defend those rights within court, as well as through purely regulatory remedies.
Let me just also pick up, what does Huawei, what do they do? What does TikTok, what do they do when they're faced with these new restrictions by the United States? The first thing that they do is they go to US court. And that is really, that's the kind of action that we would predict in our models, which is that this is not just a China versus the United States. This is an example where Chinese companies are embedded within the US political system as well. And so, they start to activate legal redress. And at least in the TikTok case, it looked like the case that they were bringing was going to undermine US national security law, and because of the arbitrariness of the US decision. And so that's kind of an example where you start to get this, the consequences of openness playing out across the jurisdictions. Just to give you one more example where, the United States is pushing European capitals around about what they should be doing on Huawei. And then Huawei, they come and they do basically, a campaign across Europe where they put up this slide that says, "Prism, prism on the wall, who's the fairest of them all?" I mean, it's this amazing slide presentation where they're just cueing Snowden, and they're saying, to the business community of Europe, that's who they're giving this presentation to, is saying, look, you're going to be spied either way. And they're cultivating a coalition within Europe that will support them on business grounds and say, you guys, Europe, Deutsche Telekom, go lobby your governments, because in the end, this isn't going to matter. And so that kind of interaction is very much in line with our argument.
Excellent. The next question is from Francesca Burlington, and she asks, could you speak to the increasing regionalism of the European Union and its effects on this, i.e. Brexit, increasing rifts between Western and Eastern European states of the EU?
So I think one of the big questions about Brexit is going to be about the adequacy decision that, the United Kingdom will no longer be a member of the European Union, and the European privacy rules require that third-party countries have adequacy. It looks like there will be some kind of adequacy decision, but I think that ultimately it does reduce the capability of Europe to be a powerful actor in a lot of these information domains because they are fragmented. I think the issue which I'm very interested to watch is this conversation about what I would call information sovereignty. It's the idea that the European Union will have its own, interests involved when it comes to data networks and data politics. And so for a long time, there was just an agreement that, the internet should be liberal. It should be an open platform. It should be one where free trade liberalization rules. But increasingly, Europe sees itself as disempowered through the liberalization of information systems. It doesn't have a major player in any of the kind of new platforms, whether it's social media or search or e-commerce. And it's understanding that that's putting it at an economic and political disadvantage. And so you're going to see, I think, actors within Europe pushing for a whole bunch of different rules, whether it's about antitrust or about data localization systems, different rules that will try to rebalance that. And what I think is really interesting is that it's not just a European conversation. You see American politicians, whether it's Elizabeth Warren or Amy Klobuchar, or people also on the right in the Republican Party making these same types of arguments. And so I imagine there's going to be a set of coalitions, transatlantic coalitions, that will push for a recalculation of the role of Silicon Valley in markets and politics.
Thank you. We're happy to have others ask questions if they would like. If anybody has trouble finding the Q&A and opening that, or you're on the phone or something like that, you can raise your hand if you have that option, if you don't have access to the Q&A.
Maybe while we're waiting to see whether other people have things to say, just to add to what Abe said, Europe also has a new data regulation bill coming out, which is supplementary to the Privacy Act, the privacy regulations that we've talked about, because it is primarily about non-personally identifiable information. And so there has been huge maneuvering and jockeying happening over that, where Google, for example, sought to target one of the commissioners, Thierry Verdier, whom they perceived as being potentially hostile to them, with various forms of opposition briefing and trying to damage his reputation in advance of the fight that is happening, but also with a lot of disagreement and dispute specifically around these questions of data localization. The original version of the directive, which is what Europe calls a bill, was pretty strong on data localization requirements. This has been watered down thanks to opposition from the Trade Commission, which is very, very strongly opposed to this. But you're seeing very definitely those kinds of politics are playing out in a very, very direct way right at the moment in Brussels. A lot of fighting and disputing exactly over this, and this is a proxy as well for this broader question of to what extent does Europe need to be strategically autonomous in this area of data and privacy.
So other questions out there from anyone? The Q&A. Oh, we do have a Q&A. Emily, I'll let you take that.
Excellent. So from Luke Kula, we have a question. Do either of you have any background information as to why Europe has historically had stronger protections of data privacy and why the US has had weaker?
I'm going to leave that to Abe. He has a book, Protectors of Privacy, which you need to rush out and buy from Cornell University Press, but he can give you the Cliff Notes version. Abe, you're on mute.
Yeah, thanks, Henry. Bye now, as he said. But yeah, so in that book, what I look at is first, why there are differences in the United States and the European Union. And what you see is really there are historically contingent processes at work in the United States and Europe. They present almost the exact same bills. So the US Privacy Act, which passed in the 70s, it originally contained regulation for the private sector, but the credit reporting agencies, they were very good at getting those excluded. And when you look in Europe, some countries passed privacy laws, but many didn't. And so we often think of the European Union as like, oh, of course, they just protect privacy. But up until the 1990s, Spain, Italy, Belgium, they didn't have any privacy laws, not even the kind of for the public sector. And so, the story of Europe is really a story of the European Union, its creation, and its creation of the internal market. In the 1980s and 1990s, it creates this internal market for goods and services. And those few countries that had privacy laws, they panic, they freak out because they're like, well, if you can create, go to Belgium and put your company there, then, if I'm Germany and I have data protection rules, that they'll just be flouted because they'll just go to Belgium or to Italy. And so the countries that had those strong rules, the privacy regulators in those countries, they basically put a gun to the head of the commission. And they said, if you want to go ahead with the Schengen Agreement, the internal market, you have to pass these pan-European privacy rules. And that's where it really starts. And unfortunately for the United States, we did not regulate private actor data before it became a real thing. The European Union passes those privacy laws in 1995. There's no Google, there's no Yahoo, there's no commercialization of the internet. And so for them, they didn't really face the type of private sector pushback that the United States now faces. Now the genie is kind of out of the bottle in the United States. And so it's a really hard thing to fight back against.
Okay, we have two more questions. One from Erin Monforti. She asks, can you clarify why Apple is pushing for a more protective data privacy scheme in the United States? What is the strategy for their involvement given, as you said, their relative lack of involvement in data control? Do you think they will be effective in exerting that pressure given the imperfect overlap of their operations and Facebook or Google's?
So I think there are a couple of things happening here. First of all, as Abe described, we see how it is that the politics has changed around privacy and around surveillance over time in the United States, so that back in after September 11th, 2001, it was obviously very, very hard for companies to defend keeping information away from the authorities. Then post Snowden, it suddenly became something which could become a important part of a company's brand. And Apple has always been committed to that. So I think that's a very important aspect of what we see. Second thing is that, of course, Apple's primary, the way it makes money is twofold. It makes it through hardware and it makes it through the App Store. Those are the, so the major sort of parts of Apple's profit model. But it is in a overlapping market where it sees its rivals as being companies very often such as Facebook and Google. And those companies have very, very different commercial incentives than Apple does when it comes to personal information. In a sense, for Apple, personal information is it's nice to have, but it's not an essential part of the model. If you are Google or Facebook, this kind of personally identifiable information is part of the essential business model that you've built up for yourself over the last period of 10, 15, 20 years. And it is an essential part of your ability to appeal to potential advertisers by saying you can give targeted advertising in a way that other less all enveloping businesses cannot. There are debates as to how good targeted advertising actually is, but that's a whole different story. Final thing, though, which is a bit of an irony, is that Max Schrems has now targeted Apple. So a few days ago, he announced a suit against Apple because of certain features of Apple's browser, which provide continued information to advertisers, which allow these advertisers effectively to figure out who you are as an individual and to build a profile around you. Apple has talked about getting rid of this, but has pushed back getting rid of it because of pressure from sort of companies that use Safari, and Schrems has used this as the opportunity to launch a request for effectively a request for Apple to be investigated too. So the picture that we showed at the beginning, Tim Cook may not have the kinds of warm fuzzies about European Union law that he did a few years ago when that picture was taken.
Excellent. From Professor Stephen Heyman, you've touched on this briefly, but would you please say more about what impact the change from Trump to a Biden administration may have on these issues of privacy and security?
Let me just say first that, U.S.-European relations on privacy were headed for, I think, a major disaster if there hadn't been a switch in administrations. The Trump administration really has no regard for the European Union and also doesn't really have any regard for multilateral conversations. And so I was expecting if a Trump administration had been reelected, they would have just tanked any kind of future privacy agreement. I also think that there is a real opportunity in a Biden administration. This is just to get to the next question a little bit as well, for some kind of comprehensive privacy changes. There's not going to be I don't think, a new law because of the way the Senate is configured. It'll block any kind of radical privacy changes, but you will see an administration that takes privacy much more seriously. If you think, John Kerry was just appointed the climate czar for the new administration. His brother Cam Kerry is a longtime advocate of privacy legislation, comprehensive privacy legislation. And so I think that it will be a very different tone in Washington in this regard. But I don't think there's going to be comprehensive privacy legislation simply because there's not going to be any comprehensive legislation in the next Senate. So I think it's going to be very difficult to get over that logjam.
Just to clarify for the recording, I'd like to read that second question that you referred to. So from Kristen Merritt, we have the question, do you think the US will ever adopt a comprehensive framework like the GDPR, or do you feel any comprehensive laws will continue to be enacted on a state-by-state basis, the CCPA, for example? And I can go on to the next question, or do you want to answer that in any more detail?
Henry, do you have?
Not very much more to say than what Abe said. I mean, clearly we see the California and the debate around the legislation in California being a driver to some extent for state-to-state stuff. And one way in which you could see comprehensive legislation happening is if you get sufficient numbers of states adopting differing privacy laws to the point that business decides that it is just too much of a pain to try and keep complying with these 50 different regulations or 40 or 30 or however, and it decides that a federal act is a better way to go. So that could happen, but as Abe said, given the massive polarization that we have and the lack of any clear majority in the Senate, I think it's going to be very, very hard to get comprehensive privacy legislation through anytime in the foreseeable future.
Thank you. And so the last question we have open at the moment is from Sylvia Wallach, and she asks, when considering the clash and collaboration narratives, is there also some indication of how these different factions are branding themselves and the consequences of messaging? For example, security proponents branding themselves as collaborative champions and or civil liberties groups being seen as embattled or litigious.
Okay, that's a very good and very complicated question. So if you think about these groups, they tend to appeal to different notions of what the interest of citizens is. So you see privacy activists tending to, of course, they focus on privacy, they focus on civil liberties, and they very often now see the state and business as being equally problematic. And that actually is a change in the United States over the last 10 to 20 years. There used to be a much stronger libertarian flavor to many of the privacy advocates. Now they're much more focused on, they're focused on business as well as the state as being potential invaders of privacy. if you look at the security side of things, they are focusing on the safety of citizens, and they are arguing that privacy laws very often provide a kind of a retrograde means of hobbling on sort of the security actors who really are the people who have the general interest in their sort of hearts. And if you want to see examples of this at the moment, you see people like, say, for example, Stuart Baker, who writes frequently from Lawfare, and I see has a typically kind of, sort of how it is that the Europeans are sort of lunatics podcast that he has just put up this morning. This is a pretty regular feature in Stuart Baker land. So in terms of broader branding, it's, very often, the reality is that in the United States, the groups who are really concerned about this, it's not so much that they're branding themselves as being scrappy and litigious. They are scrappy and litigious because that is where the only places that they can go are. They tend to be relatively underfunded as compared to business lobbyists. They tend, very often to resort to the law courts because regulators aren't nearly as interested in talking to them as is true in the United States. That might change if you begin to see a more federal privacy bureaucracy beginning to really get established. That started to get embedded under the Obama administration, and you could see a significant administrative stuff happening, in which case you might begin to see a different dynamic for US privacy actors becoming more engaged in the regulatory process because there are regulators who will listen to them. But that again is going to be, I think, less about branding and much more about the opportunities that are open to them. And I guess Abe and I, we tend, because we're political scientists, we tend to focus on things like, what are the opportunity structures and how they shape strategies more than on the branding stuff, perhaps simply because the tools we have are not so good at understanding that.
I would just say that I think that the legitimacy of the claims of the political actors is really important, and it often is part of the resources that they use to forward their agendas. So the security community, they ran 9/11 as far as they could take it because it was like a way to legitimize their claims. And currently, the specter of big tech and the danger that big tech provides, the civil liberties community is really riding that. And, I have some work where I look at the passage of GDPR, the European privacy law. And what you see there is that when the Snowden revelations happened, it really changed the narratives that those privacy actors could use. They were losing. GDPR was going to get watered down. And Snowden happens, and it provides them a whole toolbox of stories to tell the world about how big tech is really in cahoots with the United States government. And it put not just big tech, but also European firms that wanted to water down the privacy law just as much on their back footing, because they couldn't rely on this is going to hurt efficiency, this is going to hurt, the typical business story. Instead, they had to kind of confront this. Oh no, the big tech companies are in cahoots with the US government. And so I do think, I'm not sure. Branding, I think, is hard because it's often cheap talk and, it's not really what's going on. But I think constructing political narratives is really a powerful resource to fight your battles.
Thank you so much, Professors Abraham Newman and Henry Farrell. We greatly appreciate your joining us for this lecture today, and I want to congratulate you again on winning the 2019 Roy C. Palmer Prize in Civil Liberties. And we hope this lecture was also enlightening for you in terms of the questions. And thank you again. And if I could say, let's all thank Professors Newman and Farrell, I would do that. But obviously, we are on Zoom, and that's not possible. But again, thank
you so much. We are so honored. It's so wonderful to have our book showcase like this, and for all the work you've done to put this event together. We really appreciate it.
Of course, absolutely. Take care. Have a great Thanksgiving too.
Yes, stay healthy and happy, everyone. Bye.
Yep.